Today that the decision to drop virtually all of a now infamous voter intimidation case against members of the new Black Panther Party may have reached all the way to the White House. A former top DOJ official under President Bush, Hans von Spakovsky, has been investigating the evidence, including a review of the White House visitors log. Here is what that evidence shows. In November 2008, members of the new Black Panther Party intimidate voters and poll watchers at a Philly polling station. In January 2009, before President Bush leaves office, his Department of Justice files charges of voter intimidation. The new Black Panthers fail to even defend the case, meaning they default in the case, handing the DOJ an easy victory. On April 2nd, 2009, the court clerk enters a notice of default. 6 days later, the number 3 official at Justice, Tom Pirelli, who was reportedly the man responsible for eventually ordering that this case be dropped, meets with a top White House lawyer, a woman by the name of Cassandra Butts. Now, Butts is a longtime friend of President Obama, and also a former NAACP lawyer. She describes herself as, quote, as close to Barack as anyone while at Harvard Law. On April 17th, a judge gives Justice until May 1st to officially request a default judgment. On the day of the deadline, the DOJ's Pirelli again goes to the White House and again meets with Butts. That same day, the trial team is instructed not to file for a default judgment, but to seek an extension. May 6th comes around. The trial team circulates a memo in support of the merits of their case. Late that same afternoon, Pirelli again goes to the White House and again meets with Cassandra Butts. On May 13th, 2 days before Justice must either move for a default or drop this case, DOJ political appointees seek the opinion of the appellate section chief, Diana Flynn. They want her take on it. Flynn concludes that the case has merit and should be pursued. That same day, DOJ's Pirelli travels again to the White House and again meets with Cassandra Butts. Less than 48 hours later, the case is dropped over the advice of Flynn, over the advice of the trial attorneys who are on it. It is dropped against 3 of the 4 defendants, and a watered-down injunction is filed against the 4th. Hans von Spakovsky was a commissioner on the Federal Election Commission under President Bush. He was a supervisor within the voting rights section, and he is now a senior legal fellow and manager of the Civil Justice Reform Initiative at the Heritage Foundation. Hans, thank you so much for being here.
Megan, thanks for having me on.
This is quite something. According to the Washington Times, in an explosive report that came out last summer, they put this decision on Tom Pirelli, who's the number 3 at Justice. They said he's the one who ultimately authorized the dismissal of this case, which adds fuel to the fire that this was a political decision and not one that was based on the merits. And now we hear, according to these White House logs, that Pirelli was meeting repeatedly with this woman, Cassandra Butts. Put that in perspective for us, Hans.
Well, look, there's a lot of deputy counsels in the White House counsel's office, but Pirelli is meeting with the one counsel there who not only is a former lawyer at the NAACP Defense Council, which was trying to talk the administration into dismissing this case, but she was a woman who had been blogging prior to the Obama administration, criticizing the voting section and the Bush administration for their handling of voting cases.
So let me ask you this, as somebody who's been within the DOJ, has worked there, is it unusual for a guy, and Pirelli, that's the number 3 guy at Justice, is it unusual for somebody like him to be going over to the White House so often and meeting with a top staff or a top attorney like Cassandra Butts?
Well, I don't think it's unusual for top leaders, and Pirelli is the number 3 guy at the Justice Department, to go to the White House. But we have this very strange coincidence of him going there on key dates that these bizarre decisions are being made in the new Black Panther case. And the one lawyer he's meeting with is the lawyer who apparently was most interested in voting rights cases there. And, you know, we've never had the White House deny that they were discussing this case. They've just been manifestly silent about what happened during those meetings.
The other thing about Cassandra Butts is she, according to her own admission, is very tight with the president. Obviously, he put her in this position at the White House. She's a top lawyer. She was a top lawyer there, and they spent time together at Harvard Law School. She says no one was closer to him than she was. And does that suggest to you, Hans, that this may have been discussed by Cassandra Butts and President Obama?
Well, I think it's certainly a possibility because, look, the president was very interested in voting issues. As you know, he was one of the lawyers for Acorn when they sued over the National Voter Registration Act in Chicago. And in fact, I think he taught a class on election law, including the Voting Rights Act, when he was at the University of Chicago.
As a practical matter, you've been inside of the DOJ under a different administration, clearly, but is this the way things get done? You send the Justice Department, just so people know why this is a big deal, it's not supposed to be this political body. It's supposed to enforce the law for all Americans. So if you've got the number 3 official going over to the White House and taking his marching orders from some White House lawyer who may or may not have been pressured by the NAACP, it's a problem.
Oh, it is a problem because we don't want the Department of Justice making law enforcement decisions based on politics. And in fact, Attorney General Mukasey, when he came in, he issued a very strict memorandum that limited contacts between officials at the Department of Justice with the White House because he wanted to avoid any idea that there was anything partisan going on in these kinds of cases. And, right now we don't know, but perhaps that these meetings may have violated that memorandum, which I don't think has been withdrawn by the Obama administration.
Well, that's interesting. So we'll have to follow up to see if that protocol has been ignored or if reversed, and if reversed, then why? Hans, I have to ask you, because when you were at the Justice Department, and I mentioned this when I interviewed J. Christian Adams, the whistleblower, last week, there was criticism of you. And the accusation was sort of from the other side, that when it's a Republican Department of Justice in play, they defend certain voter intimidation laws and don't pursue others. And in particular, the allegation was that part of the motor voter law that requires states to make registration available at social service agencies wasn't being enforced, and that you were somebody who said you didn't think that there was any merit to the allegation and you brushed it off without any action. I want to give you the chance to respond to that.
Sure. Well, that is blatantly untrue. In fact, if you look at the record of the Bush administration, you'll find that they filed more lawsuits to enforce the National Voter Registration Act than the Clinton administration did. Most of those cases were to enforce the provisions that require voter registration at DMVs and at public assistance offices. I recall at least 3 cases that were filed against states where they said that the welfare offices were not properly supplying voter registration to people coming in.
And Hans, I have to ask you this question. I know you've been following the coverage and the whistleblower interview and so on. Can you try to put it in perspective for our viewers? If J. Christian Adams' accusations are true, and the DOJ actually has a policy in place now of not pursuing the law, not enforcing the law, where the defendant is black and the victim is white. Moreover, he says there is also a policy of not enforcing that portion of the law that requires ineligible voters to be taken off the rolls because, according to him, political appointee Julie Fernandez says that's not going to help turnout. If that is the case, and the DOJ denies it, but the whistleblower says it's true, is that a big deal? I mean, how big a deal is it? Put it in perspective.
Oh, it's a very big deal, and in fact, I know it's true because it's not only in accord with my own experience at the Department of Justice. I've had other sources that I still have at the department confirm that this is all accurate and true. And what it means is that the Civil Rights Division, which is very important to making sure we have impartial and fair elections, is being run for political purposes and partisan political gain, and in a way that is completely inappropriate to a law enforcement agency.
Wow. Well, we're going to stay on it. We're going to stay on it. Hans, thank you. Hope you'll come back.
Have me anytime.
All the best. Well, coming up.